Lisa in Honolulu, Hawaii. You disagree with me about the Supreme Court?
Yeah. So I just wanted to shed a little bit of light because I get a little frustrated when people boil down the whole Citizens United case into one soundbite, which is that corporations are people, and it has
and money is speech.
Right, but have you read the case?
I not only have read the case, I wrote a book about the case. I've read the case. I've given speeches on the case, and if you're going to say that they didn't say corporations are people, you're right. It doesn't explicitly say that. Although in the dissent, you'll notice that Stevens comes right out and says that my colleagues are essentially saying that corporations are people.
Not that is but no, that's not my issue. Okay. My issue is more with that the main purpose of the decision and the reasons that they came to it, and actually what the decision was about is what's totally missed on people. It's about political speech. Corporations being deemed as people or even having a right to political speech has been something that's been settled for like 30 years. And what Citizens United
arguably 100 years, but yeah.
Okay, well, as far as the Supreme Court is concerned and whether or not it's a constitutional right to that speech. So what I would really love for, the political talk guys to do is to really dig into and educate people as to what the problems of the outcome of this case was, which is that Congress needs to get its act together and put together a comprehensive bill that will withstand Supreme Court and constitutional scrutiny. And the problem is that what they came out with was conflicting rules. So since 1978 with, it was like First United Bank versus Pilate, they said that corporations, political speech and protections of political speech, which is like the highest protection of all of our, First Amendment rights is political speech, that applies to corporations. And that kind of came about because it was connected with other things in the law of campaigns reform back then.
That came about because the First National Bank, Massachusetts had a law that said that corporations, and it might have been limited to banking corporations. I don't recall. It's been a decade since I read that case, but that there was a law in Massachusetts that said that a corporation cannot put money into political campaigns unless it's an issue that directly involves them. And the First National Bank of Boston had gotten involved in a political campaign that did not involve banking. And so Frank Pilate, the secretary of, or the, what do you call it, the chief law enforcement officer for the state, the attorney general, went after them, and this got taken to the Supreme Court. And you're right, the Supreme Court in First National Bank versus Pilate said that the bank was that the corporation was recognized as a person under the law and therefore had First Amendment rights, or had the right to political speech. It followed on Buckley versus Vallejo. You can take it all the way back to Santa Clara County versus Southern Pacific Railroad in 1886, or if you really want to get serious about it, you can take it back to Dartmouth versus U.S. back in 1815. But I think all of them are wrongly decided. This doctrine that corporations have standing under the Constitution as persons is something that has never, ever been passed by any legislature anywhere. This is a wholly invented doctrine by the Supreme Court. And nowhere in the Constitution does the Supreme Court have the authority to make law, to create doctrine even. In fact, Article 3, Section 2 of the Constitution explicitly says that the Supreme Court, and Hamilton referred to this at some length in Federalist number 78, saying, they command no army, they have no police force, they have basically no power, they're the least likely to cause injury of the three branches of government, the weakest of the three. Article 3, Section 2 says that the Supreme Court shall operate under regulations specified by Congress. So, but no, the Supreme Court rose up in 1803 in Marbury v. Madison and said, no, we can strike down laws that we don't like. And Jefferson went nuts when that case came down. He said, if this
what's constitutional is what they said. We will decide what is constitutional. And
that's exactly right. That's exactly right. When they struck down the Judiciary Act of 1789, and in Marbury versus Madison in 1803, and Jefferson said, if this decision stands, then indeed the Constitution has become a thing of wax to be molded in the hands of an unelected judiciary. He said the Constitution has become a fellow de se, a suicide pact.
Before Marbury versus Madison, the Supreme Court was kind of a joke. And their powers.
They weren't a joke. They were the court of last appeals. And by the way, between Marbury versus Madison and Dred Scott in 1856, they did not again make a decision on the constitutionality of anything. They went back to deciding which dog ate which chickens. I mean, they were the final court, the final arbiter of disputes between people and whether the modern corporate form pretty much didn't exist back then. But between people and businesses and states.
That was deciding a decision about that was a decision about what are states' rights, what are because it was a conflict between states. So the Supreme Court does have jurisdiction over that. They don't just make up laws willy-nilly. But I mean,
well, they do.
Citizens United, going back to Citizens United,
in Citizens United, I would say that they did make up a law.
But when you say that the case came out and that the main point was that corporations are now considered people, you're actually hanging the whole entire, you're actually kind of washing over the whole case and its importance.
The rationalization that they used, and Elisa, if you've read the case, you know this, the rationalization that they used was that we, the people, have the right to hear, and that's the same thing as speech. And corporations are the most well-informed about economic issues. And so by depriving corporations of the right to speak, we're depriving ourselves of the right to hear, and therefore we're limiting free speech. That was the majority opinion, the 5-4 decision. And that, to me, is the most twisted pretzel logic that I've ever heard. And Stevens called that out. I'm assuming you've read the dissent.
Yes. And what I'm saying is that I don't think you need to hang your hat on the dissent of that corporations are people. I think the bigger point is that Congress needs to come up with the wording. Now, oftentimes they write laws that are way off, that they're just, the wording is awful. And the Supreme Court...
Okay, I don't disagree with you. And in fact, I think Congress needs to do two things. One, in the 8-1 part of that decision, they said, why don't Congress make laws requiring transparency?
You're listening to the Thom Hartmann Program. Call 866-987-THOM.
So Congress needs to pass a law requiring transparency and doing away with 501c4s. And number two, Congress needs to regulate the Supreme Court and say, sorry, you can't say that money is speech anymore.